a senior family lawyer at Parket Cresswell, Fulham. Good morning to you.
Good morning to you, John.
Could you just outline for us, in far better detail and with far more authority than I could possibly muster, what the law actually says in these circumstances at the moment, where someone may or may not have been guilty of adultery, what they can do about it, and what their options are before the courts?
Their options are before the court. They can get divorce. If your spouse has committed adultery, you can issue a divorce petition on the ground of adultery. However, a divorce petition on the ground of adultery involves overcoming a number of complex procedural hurdles. Mm-hmm. So, number one, you have to your adulterous partner has to have had sexual intercourse with a consenting adult, mm-hmm, who is of the opposite sex.
Yep.
Hurdle number one. Not any sexual activity, sexual intercourse.
Yep. That's
hurdle number one. Hurdle number two, you have to find it intolerable to live with your spouse. So you actually have to be living with your spouse when you find out the adultery has taken place. That's hurdle number two. Hurdle number three, you can only live with your spouse for up to 6 months after you've found out that the adultery has taken place. Mm-hmm. Hurdle number three. And then hurdle number four, which is often a real major problem for us divorcing people, is that during the course of divorce, you will receive a divorce petition, and containing that divorce petition will be an acknowledgement of service. It's basically a receipt form which you have to send back to the court to say you've safely received the divorce papers. And question 5 of that says, in the case of a petition alleging adultery, do you admit the adultery alleged? And quite often we can get difficult spouses who will leave that blank or write no. Then you're left at ground zero, because then you have to prove that the adulterous spouse had sexual intercourse with a consenting adult of the opposite sex. So separation and divorce are hurtful and difficult periods in people's lives. To have all these hurdles to go through the ground of adultery could be seen to be somewhat of an unnecessary burden, because normally what I advise the clients to do is, okay, you must be aware of all these hurdles, and these hurdles can make you fall and ensure that your divorce does not go through smoothly and achieve the aim that you want. I mostly advise people to shift that to an unreasonable behaviour so that they don't have these procedural hurdles to overcome. And also, only about 14% of divorce petitions are based on the ground of adultery in any event. And another issue, which is often quite confusing now, is under the Marriage Same-Sex Couples Act 2013, Schedule 4, if you're in a gay marriage, you can't get a divorce on the ground of adultery.
Oh, really?
So another hurdle, since April 2013, legal aid has stopped effectively for all family law disputes unless you can prove you've been a victim of domestic violence for the last 2 years, or there are exceptional circumstances. So many people now are having to go it alone and face these procedural hurdles themselves. So purely as a practical lawyer, I can see that there are difficulties with continuing with a divorce on the ground of adultery.
Can I just pause you for a minute and just clarify a couple of points you said, because it was an excellent, a smashing rundown of the law that stands at the minute. But when you, am I right in saying if the couple stay together for 6 months after the alleged infidelity, then adultery ceases to be a reason for divorce? That it's not valid as a reason in court. Is that correct?
Yeah. If you've been living together for more than 6 months after you found out about the adultery, then that is a hurdle you have not been able to overcome.
Right, but you can get a quicker divorce in around 6 months if one side admits it. Is that right?
Absolutely. If one side's cooperative and admits it, if you want a quickie divorce, you either go for the ground of adultery and you have to jump through all those hurdles, or you go for a divorce on the ground of unreasonable behaviour, which does not have all those procedural hurdles.
So what do we mean by unreasonable behaviour, Elizabeth? I mean, the adultery may be a part of that unreasonable behaviour, it's just that you're calling it something else. Is that right?
That's correct. You could say something along the lines of, well, my spouse has had a romantic liaison, or my spouse's emotional loyalties now reside with someone else, not me, and I find this intolerable.
Weasel words.
Well, I wouldn't say weasel words. It's a means to an end. It's instead of boldly saying, because again, you may not know. How can you actually know that your spouse has actually had sexual intercourse?
Unless they've admitted it.
Yeah, unless they've actually admitted to it, and quite often they won't. They leave the question 5 in the acknowledgement of service blank or write no, in which case your divorce grinds to a halt and you're faced with some significant evidential burdens to overcome.
So what's your personal view about of the view of Baroness Hale of Richmond, who says adultery should no longer be a reason for divorce, full stop?
As the law stands at the moment, the ground of adultery puts so many hurdles in front of you in order to get to a divorce that I think perhaps it could be subsumed simply within unreasonable behaviour. And many practitioners do that anyway in order to avoid all these procedural hurdles. They'll just subsume the adultery, reword it, rephrase it, and use it as an unreasonable behaviour ground instead. And that is often, because as I say, unless you really don't know if your partner, unless you've actually seen it or there's a child produced or the partner admits to it, you can't actually ever be assured that your partner has actually had sexual intercourse with someone else.
But for the courts to take a view that adultery is not grounds for divorce, even though it might be subsumed, as you say, into unreasonable behaviour, that headline, adultery is no longer grounds for divorce, would surely undermine matrimony, would it not?
I don't think it would undermine matrimony. As the law stands at the moment, only about 14% of people divorce on the ground of adultery anyway, so it's not stopping people from getting a divorce, and I certainly don't think it would be particularly undermining it, because the vast majority of divorce petitions are unreasonable behaviour anyway.
And what about this notion that we should scrap the idea that one party is always at fault?
Well, one party isn't always at fault, because the other grounds for divorce are that people have lived apart for a continuous period of 2 years and that they agreed to separate on that ground, or the parties have lived apart for a continuous period of 5 years, in which case there's no consent of either party. So we do have other grounds which don't involve any fault at all. Now, we have to accept that relationship breakdown, divorce is an extremely painful period in people's lives, and it can often be worse than a bereavement. And this has to be recognised. And we also have to recognise that, I would say, in 90% of cases, only one person wants that separation to take place. And the other person will be hanging on there, desperately trying to build bridges, desperately trying to hang on to what is left of the relationship. And I think we have to acknowledge the pain that has caused. To remove fault altogether, I think, takes away the cathartic experience that people need, perhaps, when they write down the list of unreasonable behaviour. I think that is quite a healing process and gets a lot of people's chest.
But given the agony that people go through, and I'm not for a single second disputing that, would her other idea that divorces should take longer be a good scheme, in the sense that it might help people come to terms with what was happening to them? It might make them change their mind. She's saying, wait at least 12 months, or that would be an ideal period anyway, to sort out all the financial matters involved, for example, and arrangements with regard to the children.
No, I don't agree with that. I think that's a rather patronising view of people's commitment to divorce. When most people have come to see a solicitor for advice, they have agonised over that decision for many years even, months, weeks. It's not a snap decision. It's something that has been taken many moons to come to fruition. And then when they do make that decision, yes, I think that my marriage should end. I'm fed up. I cannot tolerate anymore. I think that as adults, we have to treat them with respect and process them as quickly as possible. I think waiting for 12 months is inhumane and patronising.
Right, OK. Thank you very much indeed. That was Elizabeth Jones, who's Senior Family Lawyer at Parpet Cresswell, Fulham. I'd love to know your thoughts on this. 10345 606 0973 is the number to ring, or text at 84850. We're talking about this proposition.